Hello everyone, I'm Debojit Das and welcome to Courts Today by LiveLaw, your daily roundup of the most important legal developments from across India. From high-profile judgments and landmark rulings to updates on ongoing controversies, we are here to break it all down for you. So let's get right into today's top stories. Starting with the Jharkhand High Court, which has quashed the criminal proceedings against the state BJP president in a case where he had publicly declared that his party would form the government within 2 months and that the current government would not be allowed to continue. An FIR had been registered alleging sedition under Section 124A of the Indian Penal Code, along with charges under Sections 504 and 506. The court made it clear that such remarks fall within the scope of normal political discourse and cannot amount to sedition. It observed that the leader's statement did not incite hatred or disaffection against the government, which is the threshold required to sustain a sedition charge. And as for the other charges, the court found no material to show that the speech was intended to insult or provoke a breach of peace under Section 504. Similarly, there was nothing to suggest that the leader had threatened anyone or attempted to coerce an individual into doing something against their will, which would be necessary to attract Section 506. Holding that, even if the allegations were taken at face value, they did not constitute any of the offences. The court quashed the proceedings as a result. In doing so, it reaffirmed that robust and even forceful political speech is protected, and criminal law should not be stretched to curb political expression. Next, the Kerala High Court has taken a bold step. It is mandated now from November 1st that all trial courts need to record witnesses using depositions using the Adalat.ai speech-to-text transcription tool. This move follows a successful pilot launched earlier this year in select courts across Ernakulam for trials involving atrocities and sexual violence, where the system apparently helped speed up proceedings and reduce delays. Under the court's directions, once the deposition is recorded, endorsed, and signed, it must be uploaded to the digital court management system so that parties and lawyers can access it via their dashboards. If technical issues arise, courts may use alternate approved tools, provided they maintain confidentiality and data security. The High Court has also instructed each district's nodal officers to ensure compliance, monitor progress, and submit monthly reports on how witness statements are being recorded in all courts and tribunals. This decision marks a significant push toward modernizing court infrastructure, bringing AI into everyday trial work, not just administrative tasks. But it also raises questions about reliability, accuracy, and safeguards in using AI in sensitive legal testimony. In another set of controversial proceedings that really encapsulate the bizarre political climate of our country, the Allahabad High Court refused to remove Kaushal Kishore Thakur as the next friend of Sri Krishna, the deity in question, in a suit related to the Krishna Janmabhoomi Shahi Idgah dispute. Plaintiffs 2 to 5 had filed an application under Order 32 of CPC alleging misconduct by Thakur, that he had filed a parallel suit in Mathura, was removed from a trust, and was misusing his position. They asked the court to substitute Ajay Pratap Singh as next friend. Thakur's counsel opposed, arguing that a deity, being a minor for legal purposes, must always be represented through a next friend under Order 32, Rule 1, and that removing a valid next friend is permissible only for sufficient cause. He also referenced classic precedents which uphold continuity and stability in representation. Justice Ram Manohar Narayan Mishra held that the allegations fell short of showing that Thakur's interests were averse to the deities, or that he had failed in his duty. The court observed that removal of a next friend is a drastic measure and should be allowed only when the cause is convincingly shown. The application, it said, failed that test. In sum, the plea to delete Thakur's name as next friend was dismissed. The court reaffirmed that next friend status should not be disturbed lightly, especially in a long-pending, sensitive title suits involving religious deities. Moving on to the Madhya Pradesh High Court, where it denied regular bail to a lawyer accused of raping and trafficking a minor girl, citing specific allegations that call for a detailed investigation. According to the court, during court proceedings, the victim identified the lawyer by name, stating she had been called to his office and raped multiple times. She initially did not know his name, but as soon as another advocate mentioned it, she immediately recollected the accused was the one who committed the offense. The accused lawyer had moved bail on grounds that the charge sheet was already filed, invoking precedents like Sukhpal Singh Khera versus State of Punjab, to argue against arrest at this advanced stage. But the High Court said those arguments don't outweigh the seriousness and specificity of the victim's statement. The court emphasized that human trafficking allegations, use of professional privilege to lure the victim, and continued sexual violence allegations cannot be glossed over at the bail stage. As a result, no case for bail is made out at this point. Next, in a notable hearing today, the Delhi High Court has pulled up the central government for its silence on petitions pending since 2017 and 2019, which demand effective enforcement of the Transgender Persons Protection of Rights Act of 2019. These petitions were filed by transgender persons and individuals who had undergone gender transition, saying that they were being denied benefits under the law and even basic corrections in their official documents. The law is clear. Rule 7, Clause 6 of the Act's rules says a transgender person can change their name, gender, or photo in official records using a certificate of identity, and the updated document must retain the same reference number as the original one. Yet petitioners complained that government departments continue to ignore these provisions. What irked the court was that the Union of India has not filed a single reply in all these years. The bench observed that at the very least, the centre owed a response in such sensitive matters of constitutional and statutory rights. Now the court has given the government a final opportunity. File replies in all 3 petitions within 4 weeks and share them with the petitioner's lawyers, who will then get 2 weeks to respond. The judges also stressed that the National Council created under Section 16 of the Act must function properly and questioned whether the guidelines circulated by the National Institute of Social Defense were ever formally approved by the centre. The case serves as another reminder how slow government machinery can be harmful, especially when it comes to implementing crucial protections for vulnerable communities. And finally, we take a look at the Rajasthan High Court that has raised the compensation in a motor accident case where a homemaker tragically lost her life, highlighting the significant and invaluable contribution of homemakers to family life. Previously, the tribunal had calculated her notional income at just 3,000 rupees per month. The insurance company argued that this was already generous since she did not have a formal job. The High Court, however, disagreed, citing Supreme Court precedents that recognize the economic value of homemakers' work when determining compensation. The court noted that the minimum wage for a skilled worker at the relevant time was 4,650 rupees per month, and adjusted the compensation accordingly. This led to an enhancement of roughly 3.15 lakhs over the original award. The judgment is an important step toward acknowledging the unpaid yet crucial labor of homemakers, ensuring it is fairly valued in legal claims. That's it for Courts Today. Stay informed, stay curious, and keep following LiveLaw for accurate, up-to-date coverage of all major legal developments across the country. I'm Devojit Das, and we'll see you again with more stories from the courts.